James Gilbert here on behalf of Mr. West.
All right, we're here for sentencing on an attempted embezzlement over $1,000, advisory guidelines 0 to 17. Mr. Gilbert, have you had a chance to review the report and recommendations?
Yes, Your Honor, we went through it last week and again this week.
All right, so I have talked with counsel. We did continue this to address some jail credit issues that we'll hear argument about. But in looking at that, it looks like Mr. West's failure to appear for our sentence date, he had either that day or the day before turned himself into Kent County Jail on another matter. Is that correct, Mr. Juliet?
Yes.
So do I understand the people to agree with the defense that OB 19 should now be scored at 0 points?
Correct.
Okay. And Mr. Gilbert, that changes it to 10 points or 10 total OB points, level 2 and 0 to 11. Is that correct?
That is correct.
Do you have any other scoring challenges?
No other scoring challenges, no.
Okay. And I guess I would indicate also, Agent Young, I know there's been some question about this. What I'm treating now is an attempt 5-year changes the grid, but doesn't change the statutory max. So I'm using a statutory max of 60 months.
Very good, Your Honor.
All right. Any scoring challenges from the people?
No.
I guess, do we want to address the legal argument on the jail credit first, since that's a PSI issue? Mr. Gilbert, your position about jail credit?
Well, Your Honor, the prosecution brought up the jail credit issue last week, and we've had a lot of conversation about it. My position is that once this court revoked bond, when my client didn't appear, granted he was at Kent County, when you revoke bond and issued a bench warrant, he was no longer on bond, and from that point of his incarceration should get credit towards the time served. So I'm stating that the full amount that is in the PSI should be credited. I think we have to adjust it for the 1 week, but that so it'll be 98 days in that 20 days that was between Kent County, him going into Kent County, and I believe him being arraigned on his matters here should be counted. Thank you.
All right, thank you. Mr. Juliet, I did receive and review and appreciate very much your detailed sentencing memo about your position with the jail credit. Any argument you want to make on that point?
I'll just supplement it, Your Honor. As of last week, the recommendation was for 91 days of credit. That would change to 98 days because of the adjournment this week. It's my position that as of last week, he should only earn 63 days of credit. That would be 70 days of credit this week. My argument, I guess, is that the 3 days on the initial arrest should be counted as credit in this case. And the remaining 28 days that he sat in the Sheboygan County Jail when he was brought here from Oakland County to today's date should be counted as well. We have 28 days unaccounted for from when he was in Kent County and or Oakland County. I'm not sure to what extent he was serving a sentence in either of those counties. But it's my position under MCL 76911B in pre-scorn, interpreting that he is not entitled to credit for those cases rather out of Kent County and or Oakland County because it's not arising out of conviction here. And I'll just quote from an unpublished case. It is People v. Murray, January 15th, 2026, docket number 375860. The Supreme Court found that the plain language of the statute, that being MCL 76911B, affords a criminal defendant a right to credit for any pre-sentence time served for the offense of which he is convicted and not upon any other conviction. So when he's convicted here, he turns himself into Kent County and begins, he's in their jail there. He's then transferred to Oakland there. He is in their jail because of their cases, not because of our case. I understand there was a bench warrant. I think that's immaterial, especially when the Supreme Court has interpreted the statute that he's entitled to credit for the offense of which he is convicted and not upon any other conviction. So I believe those convictions down there do not entitle him to credit here. So it's my position that he's only entitled to 70 days credit.
Thank you. Well, jail credit is a thornier issue than one might think. The statute simply says that if you're convicted of a crime and you've served any time in jail prior to sentencing because of being denied or unable to furnish bond for the offense of which he's convicted, then you give credit against the sentence for the time served in jail. Sounds simple enough. But what complicates it is when people have more than one case pending and they're in jail trying to figure out, well, why are they in jail? And the cases from the Court of Appeals and the Supreme Court over the years only give us a few clear rules. One, if there's a parole detainer, then you don't get credit because you're in jail on the parole hold no matter what. Second, if you're serving a sentence somewhere, then you don't get credit for the time you're serving that sentence, no matter what, because you're serving that sentence. Here, that might have happened in this, but we don't have enough information to sort that out. So I don't think I can apply the Givens case to deny credit for serving a sentence. Another one is if you post bond in your case here and you end up in jail on another case somewhere and your bond never gets canceled here. Well, then the case law says you don't get credit because you were serving on another case, not on this case. But there is some very strange reasoning in these cases and some of the unpublished cases that the prosecutor's relying on, that where there's two cases, or here three, Kent, Oakland, and Sheboygan. The prosecutor's saying that when he's in Kent County, even though he's got a no bond warrant with us and there's a hold on him, that even if we didn't have that hold, he'd be serving in Kent County, so therefore he shouldn't get the credit. I do think that reasoning, read broadly enough, goes fairly circular, so that if you have two cases you're in jail on, in case one, the judge might say you don't get any credit because you, even if you were on bond, you'd be held on case two, so therefore you don't get any credit in case one. But it seems to me that the judge in case two could say the same darn thing and say, well, because even if we granted you bond, you'd have been held on case one, so you don't get any credit. So somebody who's in jail on two different cases would get zero credit. And it seems to me that can't be consistent with the statute, which the cases say is to be applied liberally to grant credit. So here, when he was in Kent County Jail, it seems on review of the PSI, he was in Kent County Jail for three reasons. One, Kent County had their hooks into him for something. Two, Oakland County had a hold on him because that's where he went next. And three, I had signed a warrant for his arrest with no bond. So I would not give credit if he was in Kent County instead of on our warrant. But I think he was in jail in Kent County because of Kent County matters, Oakland County matters, and our warrant. So under those circumstances, I would grant him that credit. The 91 days in the PSI plus the 7 days that we've adjourned it. So I'll give 98 days jail credit to the incarceration imposed today. All right, so Mr. Gilbert, anything you want to say in support of Mr. West?
Yes, and first off, thank you for that ruling, Your Honor. I know Mr. West is acknowledging and trying to take care of everything that he's got floating out there, including that's the reason he turned himself into Kent County. He wants to put this behind him. It's my understanding that he's been doing well in the jail. We know that there's going to be some additional incarceration. We'd ask that to be the least amount possible. And also, if there's an additional incarceration, if any type of jail program like trustee, or I believe there's another work program that the jail is beginning to review, that my client be eligible for that. And again, I think Mr. West stands before you very remorseful and trying to get his life back in shape. Thank you.
Thank you, Mr. West. You don't have to tell me anything today, but you're welcome to. Is there anything you want to tell me or not?
Just sick of letting people down, my family, my wife, my kids. Just want to make this right and be a good dad and a good husband and try to add to my community instead of disrupt things.
Okay. How do you think that's going to happen?
I stick into my head and doing my stuff and not making idiotic decisions. Sorry, Your Honor, I'm just nervous. I get a hard time talking.
I mean, it seems to me you got a significant history of some larcenies. So your problem seems to be that you're not satisfied with what you got going on and you take from other folks. So that seems to me an easy change you can make to stop letting your family down is to stop stealing.
Yes, sir.
That's 100% in your control, right?
Yes, sir.
All right. Well, I wish you luck with that. I really do. Mr. Juliet, any recommendations from the people?
Yes, we did submit a restitution request for $7,430. I don't know if that's being stipulated to, or if we have to have a hearing on that.
Any objection to the restitution amount?
We have no objection to that restitution amount. That's correct, right?
Okay.
Otherwise, Your Honor, I would ask for a sentence of 11 months. I mean, he's what I would categorize as a serial thief. I mean, that's nearly all of his convictions across the state of Michigan. He's been on probation for almost all of them, and it stopped working. So I'd ask for an 11-month sentence.
Thank you. Well, Mr. West, there's some financial assessments, $7,430 in restitution, $130 crime victims assessment, $350 in court costs, $68 in state costs. Also, I'll dismiss the pending contempt for failing to appear because that wasn't contemptuous. He was in jail in Kent County. And the guidelines are now at 0 to 11 months. Mr. West, I mean, I hope that you mean what you said today, and I hope that you're able to do that. But for today's purposes, I mean, I have to agree with the prosecutor that this is not an isolated incident. You've got a history of stealing, and probation hasn't encouraged you to change. So now the tool in the toolbox is that you get jail. And if you keep stealing and committing felony stealing, then the next step is going to be prison. And you're not that far away from it. So I'm going to order that Mr. West serve 11 months in the Sheboygan County Jail. I'll give him credit for 98 days previously served. I will indicate that I have no objection to his participating in the jail trustee program if the jail determines him eligible.
Thank you.
Mr. West, if you want to appeal, you have to file an application. If you want a lawyer, you'd have to ask me within 6 months. We're going to hand you a piece of paper explaining that process. That's the initial one copy for us. The other one's for you to fill out if you want to take an appeal. Good luck to you, sir.
Your Honor, was that also including to work?
No. If we're doing like some work crew program out of the jail, I'm not going to approve that for felony matters.